Hello, everyone, and good afternoon. I'm Rachel Thomas. I'm an attorney in Husch Blackwell's Energy and Natural Resources Group. Before we begin, I would like to just cover a few housekeeping items. At the bottom of your audience console, there are a number of application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or if we happen to run out of time or anything, we will answer your questions via email instead. There's a PDF of the presentation available in the program materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Towards the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. All right, that's all for our housekeeping items, so let's get started with our program. Joining me today is fellow attorney John Micah Goller. John Micah brings together in-house experience with a multinational power generation development and operations company, with his background as local regional counsel for Environmental Protection Agency to guide clients with utility scale energy projects through a diverse set of permitting, compliance, product safety, remediation, liability management, litigation, and transactional challenges. I'm Rachel Thomas, and I have a background in permitting and siting of utility infrastructure. Prior to joining my role at Husch Blackwell, I was actually in-house at a multinational combined electric and gas utility, where I specialized in the permitting of all utility scale infrastructure ranging from large transmission lines to offshore wind to substations, battery storage, and solar. I continue doing that work as well as representing developers on all stages of the real estate process as well. So with that, let's begin. So here's a little outline of our presentation today. The topics we're going to cover are for both environmental and regulatory, and they include the typical types of permits for solar and battery storage, legal updates relevant to both battery and solar, challenges we've seen in our practice, and some practice pointers for your use in future planning. Our legal team will generally review the permitting requirements for a project in the context of a purchase or a sale or financing transaction. Our scope of review may be more general, for example, to highlight critical issues that could interfere with project development, or to review the permitting requirements more closely, maybe to issue an opinion letter stating that a project has received all permits required for construction or operation. If you know what we'll be reviewing and have an understanding of the studies and permits that are generally required, the types of information we want to see and the common issues that come up, you can take a number of steps to get projects done more quickly and at significantly less expense. With that in mind, John Micah and I are going to walk through the permitting requirements we generally see in our work for solar and battery storage products. Before we dive into the specifics, though, we have the following general observations that we'd like to share. Permit requirements can vary significantly from jurisdiction to jurisdiction. A permit required in one state may not be required in another, and vice versa. This is really especially true at the local level. Zoning and local permitting requirements may be completely different from one county or municipality to another. However, there are some common themes. Environmental permits are often required under either a federal law or a variation of a federal law that's adopted by a state agency. So these types of environmental permits, and when they are required, are somewhat consistent from state to state. However, it's always a good idea to hire local counsel to review all state and local requirements to confirm that a project has everything it needs. Before we get going, we have a quick poll question to get things started. So if you would take a second to submit your answer to this question, have you ever been involved in siting, developing, or financing a solar project that's located on federal land? Okay, I see some answers rolling in, so I'm going to move along. Okay, wow. It looks like a large majority have not, and some of you already have. Um, this is kind of an interesting result. So let's talk about considerations when it comes to land ownership and developing on such land. So when analyzing a battery storage or a solar project, there are really two major areas of consideration that need attention. First is the location of the project, and then the second is the size and scale of the project. The first step is to determine what kind of land you are on. Is it federally owned, state owned, municipally owned, or privately owned? Each category of land will greatly determine the types of approvals that are needed. For example, on federal land, federal agencies have adopted extensive procedures to authorize use of public land overseen by the federal government. From initial application to the final right-of-way grant, the current process to a utility scale solar project, for example, can take 3 to 5 years to complete. The easiest example is the Bureau of Land Management, or BLM, which is responsible for authorizing utility scale solar energy development through a right-of-way permit. And this comes under Title V of the Federal Land Policy and Management Act. In order to obtain such an approval, developers, there's multiple steps, but developers must, one, submit a right-of-way grant application, and two, submit a plan of development. At this stage, the BLM will request this after an application has been received and the applicable fees have been paid. This stage can take between 2 to 6 months to complete. The next stage is the environmental review process, which can take 2 to 4 years, give or take. John Mike is going to dive into more detail on that environmental review process in just a moment. BLM will then issue a record of decision following the successful completion of the environmental review process, either granting or denying the application. If the application is granted, the applicant receives a notice to proceed, or an NTP, allowing the construction phase to begin. After the right-of-way grant is issued, the permit holder pays annual rent. They may be subject to ongoing compliance obligations. There's going to be various reports that may be required. But this is just one example of how the federal government can permit a solar development and how long the process can take. What shouldn't be ignored, though, is if a right-of-way permit is required, additional agency review might be required. For example, if the land falls within Forest Service land, a special use permit might be required. These kinds of requests from various land agencies also need to be consistent with current agency laws, regulations, orders and policies, other federal laws, applicable state laws, and local health and sanitation laws. We're noticing now that under the Biden administration, they're hoping to lessen this permitting chokehold on renewables. Some of the proposals include coordination between federal agencies and lowering land lease rates, which are currently exorbitantly high, and that will feed to more development on federal land. So expect more of a streamlined approach as the administration institutes these new policies. What's not to be ignored, though, is state or municipally owned land can be somewhat similar of a process to federally owned land, but it's going to vary significantly from state to state. So state agencies usually guide the permit and review process, requiring multiple steps to gain approval for development on such land. But what we're noticing is states are issuing new programs to encourage renewable development on public facilities or other public lands. One example is some states are looking to repurpose underutilized lands, which to help meet state goals of decarbonization. So in particular, some states have gone so far as to issue renewable energy tariff that directly regulates this kind of development on underutilized lands, that lessens the number of approvals that are required. And even they have specific streamlined solar or battery storage applications just for this kind of land. The third type of land ownership consideration is privately owned land. So developing on privately owned land, which is usually where we see most development, it will require proper site control, as well as compliance with local, state, and federal regulations over the land in question. So when you're looking at this, you want to review any applicable maps, overlays, ordinances as they pertain to the land and the proposed use on that land. We'll talk about that more in more detail later on in this presentation. So for now, I'm going to toss it over to John Micah to discuss preliminary environmental assessments.
Thanks, Rachel.
Oops, sorry about that. I think I pushed it forward too much.
Let's go back on. There we go. Thanks, Rachel. So yes, we'll dive into the preliminary environmental assessment considerations for developing on federal, state, and privately owned lands. As Rachel said, developing projects on federal lands or using federal funds triggers additional environmental permitting and approval processes, which include the National Environmental Policy Act, better known as NEPA, and the U.S. Fish and Wildlife Consultation regarding threatened or endangered species. Some states also have a similar environmental policy act that applies when a project is sited on state lands or uses state funds. These approval processes may cause project design changes and other permit requirements, which can cause project delays and raise costs. Therefore, it is important to get ahead of those issues and evaluate potential environmental concerns with a site before committing time and resources to a particular location. This can be done through a desktop site characterization of the proposed location. Many developers and consultants have internal systems that combine the publicly available databases with proprietary siting tools to get a high-level look at the site. This analysis can identify red flags with the location and help develop the permit matrix. Some land characterizations to look for during these desktop assessments include significant water features, identified listed species, critical habitats, or protected and managed lands. Usually, though, a singular issue is not a deal breaker. However, early identification of items of concern will allow you to develop the project with the most realistic timeframes to complete the field investigations, consult with the appropriate governmental authority, and obtain the necessary permit and approvals. For instance, as we'll discuss later, the presence of listed species, like the desert tortoise in the Southwest, may demand siting consultation with state or federal agencies. This can mean creating a management plan for the species, obtaining a take permit, and implementing mitigation and take minimization techniques and possible investments even in mitigation banks, which all raise project costs. Not only can these resource areas and habitat concerns exist at the federal and state level, but certain local municipalities have environmental resource designations for wetlands, agricultural priority areas, and wildlife management zones. Therefore, it is vital to communicate the results of the preliminary desktop analysis across your project team and with your council. Different land features not only present environmental permit concerns, they can also lead to site design setbacks and monitoring requirements. This can force your land agent to obtain more lease and space for the project and create considerable site design constraints for your engineers. It can also complicate project deadlines for finance specialists. So needless to say, it is vital for all parts of the project group to be aware of the preliminary environmental results. I'm going to kick it back over to Rachel to discuss project size and scale considerations.
Thanks, John Micah. All right, so perfect. I have my slide up. So project size and scale considerations are a pretty significant consideration when developing a project. So depending on the size of a proposed solar or battery project, you could trigger anything from federal to state level siting board review, state level utility commission review, local zoning relief, as well as other types of state, county, or local approval. For the purposes of this presentation, let's look at utility-sponsored battery storage projects that are developed or owned by public utility companies. Such projects may be subject to Public Utility Commission jurisdiction and the need to obtain certificates of public need, as well as various environmental permits. So let's take California, for example. So in California, utility-sponsored battery storage projects are governed by General Order 131D, which requires a certificate of public necessity and convenience, among other permits. Such an application requires a complete review of the Utility Commission in a public notice period, all requiring extensive review and scrutiny over the need, the impacts, and cost of a project. Most other states require a similar type of review for similarly sized battery storage projects. However, what we're noticing is that some utilities and developers have been successful at invoking exceptions to the certificate of public necessity and need requirement. What they've done is they've argued that systems below a certain threshold, and what's most common is those under, let's say, a 50 kV threshold in most states, is considered a distribution facility, thereby avoiding some state level compliance requirements like I mentioned above. So for battery storage projects that are not utility sponsored, the analysis is centered on the type of land, like we had discussed previously, where the facility will be installed on. So for a battery storage project developed or owned by private entities, the permitting requirements are dictated by the location of the land. So whether that's federal, state, or private land, and the agency with jurisdiction over that land. The vast majority of what I've seen of battery storage projects are located on privately owned land, typically close to a substation, feeder, or other type of generating facility, and are subject to local zoning, if applicable, and land use requirements, which we'll talk about in a minute. This analysis is nearly identical for solar installations. However, solar installations are more regularly triggering state level approval, whereas battery storage does not, and this all boils down to the size and capacity of the generation. So in addition to the sizing requirements or local level approvals, most states require some variation of the same type of permit when developing these kinds of projects. So it's, for example, if a project is located along a state road, you might need a highway or a DOT access permit. Electric code compliance is usually required for both solar and battery storage. What I'm noticing now is that electrical inspectors require battery storage systems to be made available for inspection prior to final installation. So this has caused some backup on some projects I've noticed because the manufacturer may not deliver the battery in such a way that makes a unit available for such inspection. We've seen projects get delayed because the electrical inspector is not able to get in there and do their inspection. Another piece of the puzzle for size and scale consideration are interconnection rules. These need to be considered early, and early outreach to the interconnecting utility is a must. If a solar or battery storage project is proposed and needs to be interconnected to the power grid, early coordination with that utility is crucial to make sure the project stays on time. Depending on the size or the scale of the project, there could be reconductoring or rebuilding of a transmission line or potential rebuild of a local distribution feeder that might be required to support the new facility. This kind of a rebuild has a substantial lead time. We're talking years in some cases if it's a utility transmission line that may need to be rebuilt to accommodate a project. And getting a spot in the interconnecting queue can also take some time. However, a newer trend that we're seeing is some states have enacted interconnecting rules requiring utilities to get renewable projects online faster. So coordinating with a local permitting attorney can help a developer get a better sense on how long an interconnection might take. Some of these tariffs I've seen have required a utility to get a renewable development online within 365 days of them filing their initial application. So a local permitting attorney or permitting attorney well-versed in these rules will be able to advise on when and how quickly that interconnection can happen. All right, so enough on size and scale considerations. Let's, John Micah, back to you to discuss your physical footprint analysis.
Thanks, Rachel. So we'll jump back into considering how the project's footprint impacts your permit considerations. So as the project moves from a desktop evaluation to land signing and project design phase, there are additional environmental studies and permits that should be on all developers' radars. These include in-field studies that will assess the habitat available for listed species identified in the desktop assessments. The results of these surveys can trigger the need for more in-depth species surveys, including nest clearances, assessment of suitable breeding grounds, and capture and relocation efforts, all of which can be seasonally dependent, thus impacting project timelines. Some developers also choose to conduct regular meetings with federal and state level resource staff to keep them aware of what they found in these studies. For projects located on federal and state lands, the survey protocols might also have to be approved by the agency leading the evaluation or issuing the take permit. These survey protocols include specific monitoring times, data collection methods, and the sufficiency of proving evidence of absence of a species. If species are discovered and impacts anticipated, then the project will need to engage in take permit negotiations with the agency. This can include impact mitigation strategies and species management plan creation, all of which will require the careful coordination. Council can help with agency consultation and permit negotiation strategies. It's important to note that each U.S. Fish and Wildlife Service and state level agency has regional offices that take a different approach to permitting negotiations and have different levels of appetite and sophistication regarding solar and battery projects. The regional offices can differ in their application and material review time. The results of these consultations and permit conditions can place significant constraints on project design, with setbacks and fencing requirements. There can also be project construction constraints, including limits on ground disturbance and tree clearing windows. As always, this information that the agencies shared should be widely distributed across the project development team. Another major field survey that impacts both project design and permitting is wetland delineations. These are a very seasonally dependent survey. Typically, in-field wetland delineations occur in the spring as you get plant emergence but before total crop coverage. There's a small window to conduct the surveys in the fall before frost. As a developer, you want to make sure that you're reviewing the results of the survey with your consultant and counsel and assessing for possible impacts to jurisdictional waterways, both federal and state, that may require a permit. On a federal level, a permit to impact a water of the U.S. is a heavily litigated and hot-button issue for administrative rulemakings. But in general, waters of the U.S. can include both streams, some that may seem dry from the naked eye, and wetlands that also from the naked eye can appear isolated at first glance. Therefore, evaluating water features based on the definition of the water of the U.S. is highly technical and requires a careful analysis of water features. A new waters of the U.S. rulemaking is currently in development with policymakers in the U.S., in the Environmental Protection Agency, and the Army Corps of Engineers. If this rule follows a published December 2021 proposal, waters of the U.S. definition will incorporate a significant nexus into consideration. This opens the door for more inclusions of water with an ecological connection to a navigable water. This means that a jurisdictional waterway can include wetlands that either alone or in combination with similarly situated lands in the region significantly affects the chemical, physical, or biological integrity of a traditional navigable water. The water of the U.S. definition is also influenced by the courts. The Supreme Court will rule in a case called Sackett versus U.S. EPA, which will determine whether the significant nexus test, which I just mentioned above, is the proper test for identifying a water of the U.S. Depending on the ruling, this could create a direct conflict between the Supreme Court's interpretation and the incoming agency rulemaking. Until that ruling and rulemaking is issued, however, agencies have been instructed to interpret waters of the United States consistent with the pre-2015 regulatory regime, which includes more waterways than the Trump-era rule. However, given the complicated nature of the water of the U.S. determination, after you've received your infield wetland delineation results, it's important to factor the permitting implications into your project design and scope considerations. Generally, the safest practice is to microsite to avoid wetlands. This involves careful coordination with your engineers to adjust panels, access roads, and utility line crossings to avoid impacts to wetland and streams. However, a certain amount of wetland impacts are permissible with a proper Clean Water Act nationwide permit. This regulatory scheme is enforced by the U.S. Army Corps of Engineers. Common nationwide permits for battery and solar projects and their associated infrastructure include Nationwide Permit 14 for linear transportation project for access roads. Developers used to use Nationwide Permit 12, which is now restricted to oil and gas. There's Nationwide Permit 51, which is land-based renewable energy generation for land-based renewable generation facilities, and Nationwide Permit 57, which is electric utility line and telecommunication activities. Generally, to qualify for these nationwide permits, impacts have to be kept under a half acre of permanent impacts. Projects are allowed temporary impacts as long as the area are restored. Consultants will often incorporate mud mats and have other BMPs to restore the area. Permanent impacts above 1/10 of an acre require a pre-construction notification to the Army Corps. Projects can also submit their wetland delineations for a formal approved jurisdictional determination. That is a definitive determination of whether the aquatic resources in review are or not jurisdictional. This often involves the Army Corps just issuing a letter back to you saying that they agree or disagree with the findings of your submitted delineations. It is important to remember that each crossing of a water of the U.S. is considered a distinct and separate project for the purposes of impact calculation and permitting. Also, it is important to remember that multiple parts of the project design and construction can be impacted by wetlands. These activities include tree clearing for transmission line crossing, panel infrastructure, and the above-mentioned access roads and utility lines. Avoiding wetlands altogether prevents the potential for project delays because different Army Corps regional offices have different review times. Developers find ways to avoid impacts altogether by boring under wetlands, spanning over wetlands with sufficient clearance on the bank, and using best management practices to prevent felled trees from entering the waterway when tree clearing is necessary. Remember that impacts to state-regulated wetlands also may require permits and mitigation banking to counter the impacts. Therefore, your consultant and your counsel should always evaluate both the federal and state-regulated waters. Some states, like Massachusetts, even have township-level wetland acts that need to be in consideration during project development. And we have another poll for you. Do you always conduct a Phase 1 environmental assessment for your project? Great. Looks like a lot of folks do, and we'll kind of explain in the next slide kind of some of the nuances to this approach to make sure that you're doing it properly. So environmental site assessments, or commonly known as ESAs, help identify potential or existing environmental contamination liabilities at the site. They are a common part of real estate transaction due diligence and a way to receive liability protection against pre-existing contamination. Phase 1s are also a common part of solar and battery project site evaluation, as we just saw in the survey results. Although, one challenge developers can face is a question of exactly when to prepare the ESA. In most instances, a full ESA that is consistent with EPA's all-appropriate inquiry standards should be done prior to signing any agreement with the landowner. This includes a lease or land purchase that provides enough rights with respect to the property that the party could engage in activities that could result in new contamination or worsen existing contamination on the site. These agreements do not include those that provide access to only perform environmental studies or other site investigations, which also includes the Phase 1 itself. So it also not include lease options or purchase agreements where the agreement only gives the party the right to enter into an actual lease or purchase the property in the future. However, the moment that a lease or purchase option is exercised is likely too late to do a Phase 1. This is because the rights of the property that could convey liability are triggered when the option is exercised. If the lease option allows the party to construct even temporary structures, then the party is risking liability without conducting a Phase 1. Therefore, lease options and purchase agreements should only include enough access to perform necessary studies and install equipment that does not require construction if you don't have a Phase 1 in place. Another recommended field survey is a cultural or archaeological survey. Cultural resource studies are prepared to identify sites of cultural significance. This may be required as part of a Section 106 of the National Historic Preservation Act review or as part of consultation with the State Historic Preservation Office. But regardless, it is a wise idea to perform these studies to prevent project delays down the line. These surveys can inform developers about any tribal sites, earthworks, burial grounds, or other man-made features in the area. It is also best practice to prepare an unanticipated discovery plan before construction to ensure any remains or artifacts that may be discovered during construction are handled properly. We'll next discuss other environmental and related permits on the federal, state, and local level. Starting with federal. If the aggregate above ground oil storage capacity of the project is greater than 1,300 gallons, a project should prepare a spill prevention control and countermeasure plan to prevent water pollution from oil-related projects during project construction and operation. This plan will describe oil handling procedures for large machinery and smaller gasoline-powered construction equipment. State permit considerations vary depending on the state, but some permits are extremely common, including the National Pollution Discharge Elimination System, or NEPDES, stormwater construction permits. These permits are delegated by EPA for implementation within state departments of natural resources or environmental protection agencies. The NEPDES permit authorizes the eventual discharge of soil and construction-related debris from the construction site into waterways. These construction stormwater discharge permits apply whenever there is a planned ground disturbance, including clearing, grading, or excavating that will impact more than 1 acre of land. As part of the permit, the project must also prepare and receive approval of a stormwater pollution prevention plan, commonly known as SWIP. Somewhat similar to the above-mentioned SPCC, a SWIP includes best management practices and a sediment and erosion control plan to minimize the deterioration of the site and reduce the release of soils and sediments into the waterways. A SWIP is specific to each project and each project's phases. An approved SWIP requires a clear delegation of responsibilities of the construction contractor and subcontractor. Also includes inspection schedules and daily construction logs. If construction plans, project design, and timelines change, as they frequently do, the changes must be tracked in the SWIP. While this permit can be obtained by the project's engineering, procurement, and construction contractor, developers and project financiers should double-check that a NEPDES permit has been obtained before the start of construction. This even includes the limited scope of limited notices to proceed that might only impact a couple of acres. Other state-level environmental permits include those for air emissions associated with project construction, and these include construction-related emissions from concrete batch plants, rock crushers, and on-site generators. The emission limits of these sources vary by state, so be sure to coordinate with your EPC contractor on verifying the emission potential for their planned construction equipment and assess the state regulations for any permit exemptions that may apply. Projects without a source of surface water that require drinking water or that require drinking water for a source for an O&M building may require groundwater well permits. For instance, like Texas, with heavy oil and gas well use, consultation with groundwater conservation districts may also be necessary. To reduce the amount of dust generated from construction, projects may also need a water appropriation permit to withdraw water from a nearby surface source and use it to wet down roads and other surfaces prone to dust. Some states require specific submissions of these plans. For construction, the project will likely need Department of Transportation permits. These include state road utility crossings and driveway access permits for egress and ingress to the project site, as well as utility line crossings. From a project due diligence standpoint, the ALTA survey overlaid with the project design can provide an easy verification for the required crossings and access roads. It is important to note that some state permits may cover multiple crossings or access roads with a single permit, and other states require a separate permit for each encroachment into the highway right-of-way. Some states require weed mitigation plans and require site restoration and revegetation efforts that will use seed mixes of native plants, and often states place a priority on creating pollinator-friendly habitats. If you're developing a project in a state with a fairly nuanced restoration criteria, it is important to coordinate early with the approving agency to select the desired seed mix. These seed mixes can be on back order, so developers should coordinate as early as possible with consultants and the seed banks to lock in their total seeding needs. This is based on a specific criteria and your mowing and maintenance considerations and the availability of the seeds. Some states will also require electrical permits as part of the project wirings and the control stations. Now, we'll go into some county level approvals, which they have, like Rachel said, have even more variance than state level approvals. Some of these municipalities haven't even contemplated solar in their town ordinances and have not updated their code for battery storage either. So it's always wise to coordinate with the county planning commission and local judge on specific requirements. If there's uncertainty about what's required, project can seek letters from the county judge or the planning commission asserting the project permitting and approval requirements. However, there are common items that most counties require. These include road-related permits like road use agreements that grant the project permission to use certain county roads to haul project equipment, with the promise of making any necessary repairs and upgrades as a result of the project's use. Sometimes the road use agreements are broad enough to include utility line crossings and driveway access permits. But like the state Department of Transportation permits, be careful to check whether the road use agreement authorizes all-encompassing project-wide encroachments or whether the separate permit is required for each impact. Other common level county permits include building permits for the project infrastructure, like the panels themselves and the substation, and flood permits for placing any project infrastructure in a 100-year floodplain area. Finally, depending on location, a project may fall under the territorial jurisdiction of the nearby city or town, but may have similar requirements to the county. So these county and local permit requirements set the stage for Rachel's discussion of local zoning considerations.
Great, thanks, John Micah. All right, so let's talk about local zoning. So as most of you are probably aware, certain states or certain counties and municipalities have zoning and some don't. So regardless of the size of a project, developers must consider local zoning requirements if proposed on any type of land, especially privately owned land. So nearly every state has enacted a zoning enabling act or statute granting counties or municipalities the power to zone and govern the land within their jurisdiction. Not all do, and when they don't, that causes for certain considerations that need to be made when there are none. So what we're finding is that with the growing development in solar and battery storage, utilities are struggling on how to evaluate solar applications and how to update their land use regulations and achieve positive benefits for hosting these clean energy facilities. As a land use application, usually solar facilities and community scale solar facilities and battery storage are processed as any other land use permit. Most developers anticipate needing zoning approvals, like a conditional use permit or special use permit, for example, but there are countless other kinds of permits that may be required, especially when developing these kinds of projects. So what municipalities typically look at, they look at tools like their existing comprehensive plan and zoning ordinances to determine what kind of permits are required. However, in most cases, like John Micah was just talking about, a lot of counties do not have zoning ordinances that relate to solar or battery storage. As such, as John Micah was kind of talking about, planners are needing to amend these documents to bring structure, consistency, and transparency to the evaluations of solar and battery storage. We're regularly seeing, however, that where there are no solar or battery storage bylaws, or just no bylaws in general relating to, road use agreements and the like, that developers are getting more and more involved in drafting of new ordinances relating to these kinds of projects and issues, making way for a more streamlined and efficient process for local approval. I've actually worked with a couple developers on how to draft a bylaw that would help with getting battery storage permitted and developed in some municipalities. So a lot of localities have not enacted solar, like we were just talking about. We've also found that some municipalities or counties have tried to prohibit it altogether. For example, I found in Massachusetts, the General Assembly enacted a law that prohibits any city or town from prohibiting or unreasonably regulating the installation of solar energy systems. Notice it just says solar energy systems. They have not, through some research and other scholarly opinions, it's unclear whether or not they intended to leave out battery storage in this definition. But what this law shows us is that states are beginning to preempt the renewable energy field, making development easier for renewable energy growth, which is a great sign. So in Massachusetts, although the law prohibits cities and towns from completely restricting solar, municipalities and counties are still free to regulate the size, the dimension, which John Micah kind of touched on earlier, and the approval for such projects. So for example, the following could be triggered for any kind of solar or battery storage project. So here's not a comprehensive list, but a list of some of the permits that I've seen in some local review of either solar or battery storage projects. So we were just talking about curb cut or right-of-way access permits. John Micah went into great detail there. Another one is conditional use or special use permits. So in bylaws, there's usually a table of allowable uses, and in their bylaw, they'll either say, A, it's allowed by right, it's allowed by special use, a special permit, excuse me, or it could be allowed in a multitude of other ways, like site plan review, or it's not allowed at all, in which case you may want to seek a variance. So if you need to get a special permit for, let's say the solar facility or the battery storage, you'll go before a local board for a public hearing with an appeals process that could draw out your project quite a bit. And this could be in addition to that state level siting review or utility board review that we discussed earlier, or any federal review that might be required depending on how the local laws might apply. I just talked about site plan review. Site plan review is not always involved in every state or every county, but when it is involved, it's an extensive review of kind of your, let's call it your blueprint of your project, where they're going to look at everything from landscaping to access points, and pretty much the whole layout of the project, making sure it conforms with all regulations within the municipality or county. That could be all setbacks, all dimensional regulations, pedestrian access, fire department access, water access, and the like. To jump ahead a little bit, under site plan review, when they do discuss like fire department connections, we've seen some issues where some states have required in their fire safety code that automatic sprinklers must be installed on any type of facility that's of a certain square feet. So if you're installing a large battery project and they want to put automatic sprinkler systems into your battery, that's a big consideration for a developer. Should the battery sustain water should there ever be a fire? And how would you work with the local fire department or fire safety board of review to see whether or not you should or can comply with that? So that's a big one where your local permitting local permitting attorney can work with the developer to see whether or not compliance with some of these regulations can actually be done. Some other ones that are important and that I'm seeing are tree removal permits. If you want to do tree clearing, I've seen some states are trying to limit tree clearing as it relates to solar projects, which, as we all know, is sometimes a really big part of getting a solar project built, is you have to clear some trees. Some states are trying to prohibit clearing of trees. So working with a local or a permitting attorney to evaluate whether or not municipalities can do this is crucial. The area may be preempted by, state law in some cases where, the municipality might be trying to do something they're not allowed to do anyway. Some other important ones to talk about, overlay districts can come into play if you're in an area where, let's say, a municipality or county has established an overlay district, which is pretty much a district. Let's say you're in an area where your battery storage or your solar is allowed by right, but there's also this overlay. And let's say it could be a historical district overlay. You also have to comply with whatever the regulations are within that district, which can cause added cost to a project. For example, I just worked on one with a battery storage project. It was allowed by right. However, it was in an art overlay district requiring this battery to be painted in a way that conformed with the district. So these are things that, I find that developers don't anticipate when they go in and start building their projects. But as you start peeling back the onion and looking at all the regulations, there can be a ton of things that you must comply with in order to get approval for your project. Some other ones I really want to highlight are noise regulations. Typically batteries are quiet, and so are solar installations. However, if you need to put a transformer in there, or you're installing a project substation next door, and you're putting in pad mounted transformers, those make noise, and sometimes you need to consider the noise levels from a certain distance and have noise studies done to make sure you're in compliance as well. So when you're dealing with local counties that have these kind of permits and require these types of review, you're going to have to comply with everything. So this is a big undertaking to make sure you're complying with everything. So there's a substantial amount of homework to identify all the permits that are necessary, A lot of these permits might require an open meeting or a public hearing with associated appeal periods in case any interested party may appeal the local decision. Like I said, it could all significantly impact the timing of a project. I've seen projects with a 2-year timeline quickly become stretched to a 5-year timeline, simply because of the added permits that were not anticipated early enough on in the project, as well as appeals. So a note on appeals: if there is a public hearing associated with any of these projects, with any of these permits, whether it's state or local, early outreach to stakeholders is so important. I cannot emphasize that enough. Whether it's working with the town, the state, a neighbor, you don't want any surprises as you're moving forward towards your permits. So early outreach, I can't say enough, is incredibly important to keep your projects on time. So working with a local permitting attorney, as well as certain consultants, there are consultants that specialize in this type of outreach to neighbors, to even interconnecting utilities, to make sure that there's no surprises as you move along. Okay, so John Mike, I'm going to toss it back to you to kind of talk about some other of the permitting considerations beyond just these local ones. So why don't you take it from here?
Thanks, Rachel. And yeah, continuing off of how Rachel concluded there about some important practice tips for developers, for council, and for consultants that are involved in these projects, we'll kind of review some main takeaways. So project timelines. It's important to work backwards from major financing deadlines and the start of construction goals because, as we've mentioned, certain surveys and permits and hearing processes, and there's so many different things that can factor into this, can require very long lead times. Application processing times also vary by agency and even the field offices within the agency. For instance, it can take the Army Corps of Engineers 9 to 12 months to process a single individual Section 404 wetland permit. And that's a long time when construction deadlines are tight. But as we mentioned, fortunately, there's been a lot of momentum to try to reduce some of these timelines associated with the approvals to foster more renewable energy development. So the future looks a little brighter. Another thing to keep in consideration are permit expirations. So permits have terms and they expire. Some permits are in effect for a few years, some last 10 years. But many permits expire if construction hasn't commenced or isn't complete within a certain period of time. For instance, Texas air quality permits for concrete batch plants require construction to start within 18 months or else the permit expires. Texas road-related permits require construction to commence or be complete within 6 months. So it's important to see when permits are final and effective. Many permits or approvals can be subject to challenge or appeal within a certain number of days after they are issued. So that's also important to keep in mind. Project layout. We mentioned earlier during project selection phase the importance of thoroughly evaluating the entire scope of your project to ensure you have enough land to meet the megawatt demands and install transmission lines. But there's going to be the inevitable problem of needing to update your surveys and your permits according to new footprints, because we all know that always happens. Some states, North Dakota and Ohio included, have very stringent requirements that require permit amendments if there are certain changes to the layout or location. So it's very important to check in on the footprint to confirm your studies and permits cover the most current project footprint. It's easier to update surveys and permits sooner rather than later. Another issue to consider is the permit holder. The party who holds the permit is almost always the owner/operator of a project, but not always. As we mentioned, for any of the permits that are issued in the name of the EPC contractor, it's important that they're consistent across the entity. Transferability of permits is also an issue. We've run into situations where there is a risk that the lender will foreclose on the property and take over. In that situation, clients have asked us to give them a legal opinion on whether all of the environmental permits are transferable. And unfortunately, the answer is not always. For instance, in Texas, stormwater construction permits cannot be transferred and you must reapply for a new permit entirely, which can delay your construction and further mess up the project. So legal counsel should always make sure to check that the permits are in the correct party names and walk the clients through situations where permit transfers may be required. Now I'll turn it back over to Rachel to wrap us up.
Great. Thanks, John Micah. All right, before we wrap up, I have a few other things to discuss, but next I have a poll question that I'd like to push forward to all you guys. So have you co-located a solar and battery storage project together? And if so, how was permitting handled? So if you want to take a few seconds and select your answers, we'll go right ahead and kind of discuss these a little bit and their importance. All right, so it looks like most of you have answered. So let's go ahead and push this out. Okay, so a vast majority have not done this yet. And some are saying it looks like an equal split, where some are saying that the permits, handling the permits was more streamlined, and some it was just handled separately. So the reason why I asked this question is to kind of come up with strategies on how to make permitting a little more straightforward. So on the next slide, we're just going to kind of talk through this. So one way to make permitting less of a huge lift, because I'm sure if you've heard through all this, it's pretty big lift, is co-locating battery in solar. So we talked about how some, localities might have regulations pertaining to solar, maybe to battery storage, or not at all. So doing it together kind of helps. So co-locating battery storage and solar has proven to streamline the permitting process, actually. So if you want to do them together, doing it together is actually easiest most of the time. Depending on the locality, some have found that battery storage systems are accessory uses to the associated generating facility or the solar facility for the purpose of this discussion, thereby bundling the two projects together. Even when a battery storage project might be added after the fact or subsequent to the development of the solar facility. Also, other jurisdictions have interpreted battery storage projects as falling within the permitted uses for electrical substations or electrical facilities, including solar facilities. So you'd have to look at the county ordinances or regulations to see how that could apply. So if it were to apply, that avoids some added discretionary review, which can cut back on your project timeline quite a bit. By bundling the two together, battery storage is usually under the umbrella of the larger solar installations. So both facilities are permitted together rather than separately, which lessens, like I said, the amount of permits that are required because the battery storage system is looked at as part of the larger installation. Now, other than just, these two pieces of infrastructure, you can also look at consolidating certain types of applications. So the interconnection itself to the power grid, especially one of utility scale, may require FERC approval. It can require state level siting review, with the state siting board requiring an applicant to submit a siting application. So whenever a state level siting review is required, the applicant will be involved in what, like we had kind of touched on before, a detailed review and robust public participation process to ensure that the solar farm meets or exceeds all siting requirements. The siting board will look into whether the proposed development will be consistent with energy policy, long range planning objectives, environmental review, like John Micah just talked through, and make sure that it actually meets the strategic goals contained in the state's energy plan. This review usually centers on whether the proposed development will be a beneficial addition to the electric generation capacity of the state and service the goals of meeting the renewable energy targets. So that's kind of a mouthful, but as you can imagine, that kind of encompasses a lot of different agency review under kind of one application. So sometimes states allow you to consolidate these applications to the same single docket, which will consolidate the approval process in ways, hearings, evidentiary proceedings, and the like into one single docket, which is a huge help. An experienced permitting attorney will be able to advise as to whether some of the applications may be able to be combined to help streamline the process. Alternatively, a permitting attorney will also understand the timing in which certain applications should be submitted and the amount of deference different agencies give to one another. So for example, some states require certain permits be in hand before filing for some state level approval, and some localities require proof of submission of environmental permits before approving a local permit. So consolidating applications and understanding the timing of when to file these applications will keep projects on time and limit unnecessary backup when applying for various permits. So this last piece is kind of like an art form, understanding how certain agencies operate, the deference that they give each other, and how strategizing your development can help move a project along faster. So with that actually concludes our presentation. So thank you all for joining with us today. We hope that this was helpful to you and your organization. John Micah and my contact information is here. Please feel free to reach out to us with any questions you have about the presentation or about project permitting in general. We'd be happy to help you out. So as a reminder, this program has been approved for legal education hours. So to report your hours, please click on the CEU icon at the bottom of your screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of this webcast for watching and sharing if you would like. And please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to you and your business needs, so your feedback is very valuable to us. So with that concludes our webinar, and we'd like to thank all of you for attending.